Hello everyone, so today we will understand about the Article 13 Clause 1, 13 Clause 2, Doctrine of Eclipse, Waiver and Severability. And there are some multiple choice questions which were asked in the previous year examination papers based on the Article 13 Clause 1 and 13 Clause 2 are provided at the end of the video. Now let's begin with the Article 13 Clause 1. See, Article 13 Clause 1 says, if any law in force before the commencement of the constitution, means अगर कोई भी law constitution के आने से पहले ही बन चुका है. For instance, Indian Penal Code, it came in 1860. Indian Evidence Act 1872, Indian Contract Act 1872. So any law in force before the commencement of the constitution and it is in violation of the fundamental rights which are situated under Part 3 of the Constitution of India, then it will be declared void. फॉर इंस्टेंस, अगर कोई भी लॉ है कॉन्स्टिट्यूशन के आने से पहले बन चुका है और वो इट इज इन वायलेशन ऑफ फंडामेंटल राइट्स, देन इट विल बी डिक्लेयर्ड वॉइड. वो वॉइड कहला दिया जाएगा ओनली टू दैट एक्सटेंट विच इज इन वायलेशन ऑफ द फंडामेंटल राइट्स. रेस्ट विल रिमेन वैलिड. टेकन अनदर एग्जाम्पल, सेक्शन 303 of the Indian Penal Code. It was valid before the commencement of the constitution, but it was declared invalid because it was in violation of the fundamental rights. So this was held in Mithu versus State of Punjab. So Article 13 Clause 1 is pre-constitutional laws because here the law in force before the commencement of the constitution. कॉन्स्टिट्यूशन के आने से पहले ही जो लॉ आ चुके हैं उनके ऊपर 13 Clause 1 एप्लीकेबल होता है. Now 13 Clause 2. 13 Clause 2 says if the state make any law and it is in violation of the fundamental rights, then it will be declared void. So here अगर कॉन्स्टिट्यूशन के आने के बाद कोई लॉ बनाया है स्टेट ने and it is in violation of fundamental rights, then that law will become void only to that extent which is in violation of the fundamental rights. Rest will remain valid. Now Article 13 Clause 1 is pre-constitutional laws and Article 13 Clause 2 talks about post-constitutional laws. Why post-constitutional laws? Because here constitution के आने के बाद laws बने हैं उनके ऊपर 13 Clause 2 applicable होता है. So Article 13 Clause 1 and 13 Clause 2 both are having prospective effect. They have no retrospective effect. Means they are applicable to the laws which are existing in nature or future laws. They are not applicable to the laws which are not in existence or which are repealed. Right? So this was held in Keshwan Madhavan Menon versus State of Bombay, in which Supreme Court held that Article 13 Clause 1 has no retrospective effect, and even if the case is pending regarding the act which is in violation of the fundamental rights, still it remain valid though they are in violation of the fundamental rights. So Article 13 Clause 1 and 13 Clause 2 both are having prospective effect. They have no retrospective effect. I hope it is clear what is Article 13 Clause 1 and what is Article 13 Clause 2. Article 13 Clause 1 is pre-constitutional laws and Article 13 Clause 2 is post-constitutional laws, or if anything is in violation of the fundamental rights, then it will be declared void. Now Doctrine of Eclipse. See, Article 13 Clause 1 basically has given rise to the Doctrine of Eclipse. So eclipse, as the name itself says, ग्रहण लग जाना, right? Like solar eclipse, lunar eclipse. Same here in this case, if the law which is inconsistent or which is in violation of the fundamental rights, then it will not be treated as a dead or void. It will be treated to be dormant, means silent mode पे चला जाएगा till there is some amendment in the fundamental rights regarding that law. Regarding that law, it will remain to be dormant condition. Dormant condition में हो जाएगा वो. This was held in Bikhaji Narayan versus State of Madhya Pradesh. So the first time doctrine of eclipse was evolved in this case Bikhaji Narayan versus State of Madhya Pradesh, in which Supreme Court held that if the law is eclipsed because of the violation of the fundamental rights, the moment there is such amendment in the constitution regarding that law, that will become enforceable and operative. For instance, say on 20th November 1897, there is some law came in force, and after the commencement of the constitution, it was declared void, or which is in violation of the fundamental rights. So, and there is some amendment is done regarding that law on 30th December 2017. So from that date, the law will become enforceable and operative, right? So this was held in the Bikhaji Narayan versus State of Madhya Pradesh. Now, does the doctrine of eclipse is applicable to the post-constitutional laws as well? This question came before the Supreme Court. So earlier it was held that the Article 13 clause 1 is only applicable to the doctrine of eclipse. Now in the Deepchand versus State of UP, in which court held that the doctrine of eclipse is not applicable to the post-constitutional laws, means on Article 13 clause 2. But in the state of Gujarat versus Ambika Mills, the Supreme Court modified this Deepchand case views and held that the doctrine of universal applicability, that doctrine of eclipse is not applicable to the Article 13 clause 2, is not universal in nature, means there are some exceptions to it as well. So in the Dulare Lodh case, Article 13 clause 2, in which the Article 13 clause 2, the doctrine of eclipse was applicable. So the doctrine of eclipse was also applicable to the Article 13 clause 2 as well. Now the doctrine of waiver. See, the waiver as the name itself says waive off kar dena kuch cheez. Now in this case, if the person is having some right and he is also have the right to waive off his right. Now for instance, A is the owner of the property. He transferred his property to B. Now B become the owner of the property. Afterwards, once the person delivered his property or delivered his right to some other person, afterwards he cannot claim back that he is the owner of the property, right? So this is held in the doctrine of waiver. Doctrine of waiver, waiver means छोड़ देना किसी चीज को, waive off कर देना. So here if the person is having some right, then he is also having the right to waived off, and once the right is waived off, afterward he cannot claim back. But another question came before the Supreme Court that whether the fundamental rights can be waived off. Fundamental rights waived off हो सकते हैं. So in the Beshwar Nath versus IT Commissioner, Supreme Court held that fundamental rights cannot be waived off. Fundamental rights waived off नहीं हो सकते because these are basic in nature. And in the Oliga Talgis versus Bombay Municipal Corporation, Supreme Court held that Constitution or the fundamental rights, these are not for the particular individual, but these are for the whole community at large. So the person itself cannot waive off his fundamental rights. Now the doctrine of severability or the separability. Separability or the severability, as the name itself says, separate कर देना किसी चीज को किसी और चीज से, to separate it out one part from the another. So same here in this case, State of Bombay versus FN Bansara, the doctrine of severability was interpreted by the Supreme Court, in which Supreme Court held that if we can separate the valid part from the invalid part, which is in violation of the fundamental rights, then the valid part will remain valid in nature, and the invalid part which is in violation of the fundamental rights will be declared void. So in the RMD Chamar Bagula case, the Supreme Court sum up some of the rules regarding the severability and held that if the valid part and the invalid part, they are mixed up so well that we cannot separate it out, so the whole part will become void. So whole provision will become void अगर हम किसी valid part और invalid part को separate it out नहीं कर सकते, तो वो पूरा provision ही void कहला दिया जाएगा. And to determine whether we can separate the valid part from the invalid part, it is depend upon the intention of the legislature. Legislature की intention क्या थी उस time पे provision बनाने की. Now the third point is if the valid part and the invalid part is separated, but the valid part cannot become enforceable till there is some amendment in the constitution or modification is done by some legislature or the judiciary, so the whole part will become void until and unless there is some amendment is done by the legislature or the judiciary. Now if we can separate, fourth point is if we can separate the valid part from the invalid part, but together they provide some meaning of the provision, so the whole part will become void. So I hope it is clear what is, this is all about the doctrine of severability. So I hope Article 13 clause 1 and 13 clause 2 doctrine of eclipse, waiver and severability is clear. So if you like the video, please like it and subscribe it for the next upcoming videos. And there are some multiple choice questions which are for practice, and at the end of the video there are some case laws also which are discussed along with their citations. So thank you so much.